Recently, I was contacted by a reporter who asked me a very important question. What is the responsibility of a lawyer if a financial institution bellies up with client trust account money in that institution? Is the lawyer responsible for anything and everything over and above the FDIC maximum insurance protection? It's an interesting question, and I think today I would answer it a little bit differently than I answered at the time, because we've had a number of things occur that have, I think, softened the responsibility of the lawyer. And let me start from the back and go forward, I guess, by saying that the $100,000 limit for FDIC insurance protection has been lifted. It's now $250,000. Another protection that you can use is if you go in excess of the $250,000 held in trust, you can have more than one client trust account that is in more than one bank. And so that helps you isolate the amounts and the protection for the client. A third approach would be to have, especially with large amounts of money, a separate account opened up in the name of the client. In other words, a trust account for client A, so that's not part of your client trust account and considered separately and apart. It would in effect be the ownership, if you will, for the client under the client's name, and it would be the client who has the protection. That account would have the maximum insurance coverage. Yet another protection for the client would be if you've got sufficient funds to buy U.S. Treasury bills. U.S. Treasury bills in the name of the client, but it is an asset. It's not considered part of the IALTA rubric. Okay? So those are ways to protect yourself today that may not have existed before this expansion of the FDIC insurance protection. Let me go back then to the beginning of the conversation, because I think the issue is still the same. And the issue is, what is the lawyer's responsibility in cases like this? There are at least two alternatives. One is strict liability. And this is where I come out, because I believe that the lawyer is the one who selected the financial institution. The lawyer is the one who set up his or her client's trust account within the financial institution chosen. And it's into that account that the lawyer deposited the funds. And under principal agency law, the principal is responsible for the agent. So if the agent embezzled, or in this case went belly up, the principal is responsible for the consequences, and in this case the consequences are that the client lost money that was in the client's trust account. And it seems to me that the lawyer is responsible for those funds. Now, another way, for example, that I did not indicate earlier that the lawyer can protect him or herself is to buy insurance if the amounts go above the protected figure. But most lawyers, most people don't think of it in those terms. Yes, we've got the FDIC insurance, and most of us don't think, well, wait a minute, maybe there's other insurance that we ourselves could buy to protect our client. And that's something that I think we ought to do under appropriate circumstances. The alternative, though, to the strict liability issue is the standard of reasonable care. In other words, has the attorney acted in a commercially reasonable manner? Did the banking institution have a good reputation? Did the community believe that the bank was solvent? Was there any reason that the lawyer should have looked to the financial statements of the bank to clarify the solvency standard of the, or status rather, of the bank? If not, then the lawyer is presumed to have been reasonable in opening up the client trust account and depositing money into that account. I'm very uncomfortable with the reasonable standard, because I think in today's world, with so many banks failing, there is no reason to presume without due diligent investigation that any bank is solvent, that any lawyer's client trust account is fully protected beyond the $250,000. So it's just a word of caution, even in today's environment, that the lawyer needs to take more care when handling his or her own client trust account for the protection of the clients. Thank you for joining us today. Though this is a somber subject, I think it's one that we need to deal with, and I look forward to seeing you in our next adventure.